we may have a EB-5 industry again. Do you want to just kind of give us a little bit of what's been happening over the last year?
Yeah, well, if before I get to the year, let me do a little bit of like how we got here. This process of passing rules and laws in Congress, a lot of the time Congress will pass a law and they'll say, okay, let's monitor it. Let's see how the law is actually working. And if we need to go in there and mechanic it and make it work, we'll do it. So, if you look at the history of the EB-5 program, 1993 with regional centers coming in as a pilot, the idea was always Congress was going to oversee the program, make sure it's working correctly, and, update it, fix it, or terminate it as needed. Well, for the better part of the 90s, for the better part of the early 2000s, nobody was really using the EB-5 regional center program. So it worked perfectly. It wasn't really, as we all know, until 2008, global financial meltdown, illiquidity of markets, that we saw a surge in EB-5 as a source of secondary and tertiary funding. And the more applications we got, starting to get 15, 16,000 applications a year, we saw a lot of cracks in the program. A program drafted in 1993, not really tailored to meet the demands of business or the way the business is done now, there was insufficiencies in the program. And in order to fix that, you need to go back to a highly divided Congress to try to pass new laws. So, us in the industry, some of your other guests, the two of you certainly, that having these conversations with Congress, you have to go through a couple different hurdles. One, you have to explain to them what EB-5 is. Most of them have never heard it. And then once they do hear about it, then you have to answer the question of, okay, well, why does my state not get as much EB-5 funding, right? And you have this division now between, senators from rural states, and then you have senators from, the urban states, right? More popular states, more popular cities, New York, Miami, Los Angeles, Chicago have historically received very large sums of EB-5 financing, whereas, some projects in rural, Wisconsin, rural Mississippi have not received EB-5 financing. So, you could try to explain how EB-5 works and how economic modeling works, and, the job numbers in those states are going to be much less because the raw materials are not coming from there. But that's the hurdle you have to breach. So we kind of went through this process in Congress starting, somewhere around 2013, 2014, trying to get EB-5 reform. And, anytime we came to, a draft bill being put out, it was essentially dead. No agreement could be made between industry and Congress, and we just kept moving along with the EB-5 program. So at one point, I'm sure you guys remember, I think it was actually Senator Grassley himself that said, why are you always putting it on Congress to come up with a solution? USCIS, you're an authorized government body, you're in the weeds of EB-5 every day. Why don't you come out with new regulations? And, USCIS already was always flirting with the idea of, do we have that power? Do we not have that power? And then, they took that affirmative step in 2021, coming out with their own regs, during the Trump presidency of a reform of the EB-5 program, most significantly to us in the industry and to our investors was a raising that minimum investment amount to $900,000. So at that point where you have my friend, colleague, client, Colin Baring and the Baring Regional Centers, they decided to step in. They said enough is enough. They stepped in with litigation and they tested USCIS of whether or not they actually had the authority to raise the minimum investment, to change the rules and regulations on their own. As a result of that lawsuit, we found out that USCIS did not. The interesting point of that lawsuit was not necessarily whether or not USCIS had power, but if you remember, Trump was getting around Senate confirmations of key government positions by installing acting directors rather than Senate confirmed directors. And it turns out an acting director does not have the power to shape policy. So as a result of that, the USCIS regulations were reversed. We went back to the EB-5 we always knew at 500,000. but we had a termination date set for the program in June 30th of 2021. So we kind of saw, a marketing conversation with clients of this is your last opportunity to file at 500,000. And we saw a large number of investors file in June of 2021. Then the EB-5 program expired. The regional center program, that is, the direct is permanent. The regional center program expired. We all in the industry assumed that the program would be extended once we had a new federal budget in the US. In years past, anytime the EB-5 program was set to expire, it was tied to budget reauthorization, and we moved forward. Well, the budget expired on September 30th. Congress did not pass a new budget. They passed a continuing resolution that EB-5 was not included on. That continuing resolution took us to November, then it took us to December, and then I believe we went to February, and then finally on March 15th, we had an omnibus, a new budget for the United States. EB-5 was included with a whole host of new regulations. And one of the primary issues with this legislation is two things. The way that the way Congress was adding the new law to the Federal Register was under a mechanism called repeal and replace. And then the second is they had language in there requiring regional centers to reauthorize in order to sponsor new petitions. This rule was to take effect within 60 days. So all of us in the industry, our investors, our future clients, our partners, our developers, we're saying, okay, come May 15th, we have a new EB-5 program. We suffered as an industry from June until now. We had uncertainty for our clients, for our pending clients, regarding their green card status. But come May 15th, we're all going to be okay. We're going to be safe. We're going to be back in business. USCIS doesn't like the idea of us being safe, us being back in business, of having the security of the green card for those investors that have filed, that have been approved, that have family here. They decided to interpret the regulations on their own and take the most draconian and vicious position they could. And what they have argued, USCIS has, and they put it out in a Q&A, is that Congress requires regional centers to be reauthorized in order to sponsor existing cases or sponsor new cases. And that reauthorization requires a new $18,000 filing fee, background checks, new documents that evidence how the regional center, its members, owners, operators will conform with the new law. As we know with USCIS, getting a regional center approved is a 3 to 3.5 year process. That becomes quite difficult when the EB-5 program is only reauthorized for 5 years. So by taking this position that regional centers need to reauthorize, by not having the staff, the efficiency, the means to actually reauthorize regional centers, they have taken a 5-year reauthorization and have effectively made it a handful of months. So again, steps in Colin Baring and the Baring Regional Centers. They filed a preliminary injunction against USCIS about 2 months ago on the grounds that USCIS has interpreted the rules wrong and they are causing irreparable harm by terminating regional centers. So, what that really means is if you're a regional center, you've been operating for 10 years, right? Barings, Can-Ams, NYCRCs, the names that we all know in the regional center space, they have spent ungodly, amounts of time, sweat equity, money in establishing themselves as trustworthy partners, regional centers that have best in market projects. And with one blog post on the USCIS website, they have terminated all that credibility. That's the irreparable harm. So it's really interesting when you go through this litigation process now to see what USCIS's position is, on the action that they've taken. And this is what USCIS has said in court documents. USCIS has said that the EB-5 program, even though it terminated in June of 2021, never expired. The regional center program as a whole has never expired. The only thing that expired was Homeland Security's ability to issue visas through the State Department. And USCIS took the interpretation that since visas could not be issued, they did not have the power to issue visas, so they put the EB-5 program on pause. Very, very interesting take, right? So they're saying rather than us take any action, keep the program going, we just said, okay, we'll shut it down, right? No notice and comment period, no conversation with Congress, no conversation with the internal attorneys of can we keep the program going. They just said, let's jeopardize the green card of all the people that have already filed. We're not going to do anything. We're going to sit on our hands. And now that the program has come back, the other position that they're taking is when Congress says the new EB-5 regulations will repeal and replace the old regulations, rather than interpreting that is language to get a bill into law, into the Federal Register, they've interpreted it as the old EB-5 program is dead. Long live the new EB-5 program, but because it's dead, you do not have a regional center. So, we had hearings on this. I think, the judge mentioned himself, this is the most time, the most people he's ever had in a Zoom hearing, a lot of interested people. But, the judges agreed. The judges agreed that USCIS has made an error in law that repeal and replace does not mean the EB-5 program is terminated. It is just language of getting a bill into the Federal Register. So we've now moved on to where we've made briefs on what the remedies are. How do we move forward for USCIS to fix this harm? And, we're essentially saying that the EB-5 program was not terminated. Regional centers should not be deauthorized, be made inactive. So all regional centers need to come back as reauthorized. Regional centers will evidence that they'll comply with the new regulations, and we'll get back to business.